you like to see attendees today leave with as the most important things they need to do when dealing with creating a best defense when they're accused of trademark infringement? And Lisa, let's start with you.
I think it's important to remember, for those, we talked a lot about preliminary injunctive relief, you know, and for those potentially facing those claims, just really focusing on what you need to bring or defend such a claim. When you're defending against a preliminary injunctive case, you don't have that much time as you do over the course of the litigation. So your survey may not be the sort of perfect survey, but I think it's critical to consider a survey, and also to consider at the preliminary injunctive stage, you know, the court can consider evidence that would not be admissible at a trial. And so with that in mind, I think you can think outside the box in terms of the type of evidence that you'll submit to the district court. Now, and sort of to step back before you get to a trademark infringement case and a request for preliminary injunction, I think certainly the clearance of marks is critical. Many of the damages cases discussed are unusual. It is hard to get money damages in trademark cases, but because the possibility remains, it's obviously important to do a good due diligence before you adopt a trademark, and hopefully you never get to the phase of a claim.
Peter Reibold.
Sure. Well, I'll echo something I said before, which is just to give thought to remedies and damages early in planning for your defense. Consider what you're going to argue before the close of discovery. Often we have found ourselves, after the close of discovery, trying to develop an analysis, but limited because there was a reluctance to produce historical data, perhaps, or data on other products outside of the case, which limits the kinds of analysis that we can do. I think so. I think work with your experts, early on in the process to look at how you're going to respond to damages claims. A big focus, I think, should be on causation and what you can do to demonstrate that your sales are not attributable to the use of a particular mark, and that does include, as Lisa just said, good solid survey work. It can be very expensive to implement a good solid survey, but it can be an important element of a strong defense.